Hello, everyone. Many thanks for joining such late in the afternoon. My name is Lex Zard. I am a policy director of Check My Ads, which is an online advertising watchdog. We often say our mission is to change the business model of the internet. Not such an easy task. So today we're going to talk about one of the most consequential potentially one of the most consequential competition cases in the digital economy, which relates to Google's online advertising intermediation or so-called adtech services. The competition proceedings about this case is happening in parallel both in the United States, in the European Union. And while in both jurisdictions the decision about the liability has been reached, so Google has found to be abusing the dominant position over a decade in this market, we're still waiting for the remedies to be decided. So what would be the adequate remedies to fix the competition issues there? So today we have a fantastic panel to discuss the background and the impact of these cases to the broader digital economy. I will briefly introduce the panelists. Ariel Garcia, who is online. Hi, Ariel. Thank you for joining. Who is the Chief Operating Officer of Check My Ads. And she is one of the very few, very close observers of the case, especially in the US. She has followed daily the trials, and she has reported about them, and she will be talking to us about that today. We have Matilda Fiquet, who is an advisor to the European Publishers Council, which is an organization that works to defend the European publishers' interests, and one of the authors of one of the complaints in the European Union for the Google investigation. Alexandros Papanikolaou from European Commission, who is a competition law specialist in the antitrust division of IT, Internet and Consumer Electronics unit of the DG Competition. I hope this was correct. And a case handler in the Google AdTech case, which we're discussing today. And last but not least, Tassos Stampoulos from Mozilla. He's the head of the EU public policy and the government relations in Mozilla, where he also leads the engagement in the European digital policy. And his particular focus is the intersection of privacy and competition. So very happy to have you here, Tassos. I'm going to do 2 rounds of questions to each of the panelists, and then hopefully we'll have some time for you to also engage with us with the Q&A. I'll start with Ariel. Ariel, Check My Ads, especially you have closely observed the US antitrust case about the Google AdTech. Can you please give us a brief overview of the case and the court's finding, as well as some of the remedies that are being proposed there?
Sure. So as Lex mentioned, we at Check My Ads have been following this trial very closely. I had the privilege of attending the trial every day in Virginia throughout both the liability and the remedies phases. And so the core of this case, the Department of Justice accused Google of illegally monopolizing the tools that are used to buy and sell advertising on the open web specifically. This case matters enormously. Digital advertising remains the primary business model of the internet. And publishers, including news organizations, depend on this revenue to fund journalism. So when that market is rigged, the information environment suffers, all of us pay for it. Now, this diagram was created by the Department of Justice to explain the parts of the market that they were focused on. But what I'm going to do now is use it also to explain a little bit of how online advertising works and how the market's structured. So generally speaking, advertising on the open web today is bought and sold through a type of real-time auction system. And so publishers use ad servers to catalog and place their ad space or ad inventory up for sale. This is known as the sell side. Advertisers then use tools like ad networks to automate and optimize the purchase of ad space, and that's known as the buy side. And then in the middle, you have ad exchanges. And what ad exchanges do is match publisher inventory to advertisers. And so that's where that real-time auction happens, and it's collecting advertiser bids for publisher inventory. So the DOJ brought 4 separate claims about 3 distinct monopolies in this case. First, that Google monopolized the publisher ad server market. Next, that Google monopolized the advertiser ad networks. Third, that Google monopolized ad exchanges for open web display or attempted to monopolize them. And then the fourth claim is that Google illegally tied those products together. So publishers needed to use their ad server to get access to real-time pricing through the ad exchange. They also needed to use the ad exchange to get access to the massive amount of advertising demand Google had amassed already through its search monopoly. So if you take into account the search case, we're talking about 5 different overlapping monopolies in separate product markets. And so that's essentially the story that the DOJ told at trial. They explained that Google ran a playbook consisting of 3 main moves. First, own the demand. Google had already established its search monopoly. They leveraged it to build Google Ads' dominance. Because just about every advertiser in the world needed to buy search ads, Google accumulated an unmatched pool of advertiser demand. Second step was to control both sides. So Google acquired DoubleClick. That was the dominant publisher ad server. And with it, they got a nascent ad exchange. Suddenly, Google controlled the tools publishers use to sell their inventory and the exchange that runs the auction. Publishers couldn't access those advertisers without using AdX, that's Google's ad exchange. And they also couldn't get AdX bids without using Google's ad server. So the trap was kind of set there. And then once they set that trap, they were able to write the rules and rig the game in their favor. So once Google was able to sit on both sides of the transaction, they could see what publishers were willing to accept and what advertisers were willing to pay. They could use that information to tilt outcomes in their favor. So for example, they had a project called First Look, and First Look gave Google's own buyers a preview of publisher inventory before it went to open auction. And so they could win those auctions cheaply without real competition. That also would undercut publisher revenue. Last Look came later. That was a response to something that the ecosystem did to try and circumvent Google's dominance called header bidding. So when publishers started collecting competing bids from multiple exchanges, AdX now got to see the highest outside bid and could basically beat it by a penny. So no matter how competitive the market got, Google's exchange could always win without bidding true value. And then finally was unified pricing rules. So publishers used to be able to set different floors for different ad exchanges. So let's say that they wanted to floor AdX higher because Google charged more fees, or they wanted to diversify the partners that they're working with. Google decided in 2019 to take that away. And so the cumulative effect on publishers was severe. Google was extracting a 20% fee on every transaction through AdX. That's a fee that publishers couldn't avoid because they couldn't access those advertisers any other way. When they tried to innovate around it through header bidding or diversifying their tech stack, Google punished them for that too. And so the ecosystem was really designed in a way that every single exit was blocked. The result was that rival ad tech firms also couldn't compete. Publishers were overcharged and held hostage. Advertisers also were overcharged. Newsrooms shuttered, opacity in the ecosystem flourished, and that hurt everyone around the world. Now, in April 2025, the court agreed. Google is found to have illegally monopolized the publisher ad server and ad exchange markets and to have engaged in unlawful tying. The one claim that failed was the advertiser ad network monopoly. That claim failed on market definition. In my view, Google's jazz hands were successful here in making it seem like it makes no difference to advertisers whether their ads are on the open web or on mobile or social platforms. Now, I come from the buy side. I spent 10 years in digital advertising before I joined Check My Ads. And so I have very, very strong feelings about this. Now, one of the arguments Google made at trial, they leaned heavily on their AI ad product called Performance Max. When millions of small businesses sign up to use Google Ads, for the past few years, they've been nudged into this AI magic product. And that product buys across Google's owned and operated properties as well as the open web. It's supposed to optimize to whatever's performing best for a given advertiser. And so this product was actually cited in the opinion as evidence of the idea that advertisers are agnostic about where their ads appear. So there's no distinct market for open web display advertising on the buy side. But here's the thing. If you look at this chart that I've created, if you look at the timing of the rollout of Google's Performance Max product, you'll notice that it coincides with rising antitrust scrutiny around the world. And if you look at the decline of open web display ad revenue and the skyrocketing of YouTube, it starts to tell a deeper story. The fact that Google built a product that obscures channel level control for advertisers doesn't mean those channels aren't distinct. It just means that Google successfully trained advertisers to relinquish control and visibility. This is unfortunate for the buy side, and we're glad that the European Commission reached a different conclusion, which I look forward to you hearing about later today. Nevertheless, here we are. So the remedies phase of the trial happened in September of last year. The DOJ proposed a comprehensive package. The centerpiece of it was structural, divestiture of Google Ad Manager, meaning Google AdX and DFP, which is the ad server. Now, the ad server divestiture proposal was phased. So step one would be to open source the final auction logic so that a neutral industry body could administer it. Then if that doesn't restore competition sufficiently, a full sale could come later. But beyond that, DOJ also proposed behavioral remedies, banning self-preferencing and transaction routing, prohibiting Google from using data from its other owned and operated properties and Chrome to advantage its ad tech stack, and giving publishers access to their own data. And then finally, there's an oversight regime. 50% of AdX and the ad server revenues would be held in escrow to support publishers in switching ad servers, and there would be a compliance monitoring trustee for 10 years. Now, Google's proposal was, of course, less robust. Essentially, Google said, we'll stop doing the bad things that we're still doing. There's no divestiture, a narrower trustee scope, behavioral promises only. We've been expecting a decision any day. So what Google's defense was at trial was primarily focused on avoiding divestiture. It boiled down to them saying that, you know, divestiture is not legally warranted, it's not technically feasible, and it would hurt customers, which is funny. That last one is particularly rich, coming from the very company that the court had just found to substantially harm its customers. But Google quite likes its benevolent dictator positioning. So that's where things stand today. Again, we're awaiting a decision. It was expected early this year, so could be any minute now.
Thank you very much, Ariel. Matilda, so EPC has filed a complaint in the European Union on the issue that Ariel just mentioned. Maybe could you tell us your perspective on the competition landscape and what motivated this action in Europe for EPC?
Right. Thank you, Lex, and thank you, Ariel. I'm trying to wrap up my mind around what is left for me to say on the case, because you were very, very thorough, and actually you're going to make my intervention a lot easier. So EPC is the European Publishers Council. We represent 27 of the largest media organizations active in Europe. And indeed, in January 2022, we filed an antitrust complaint with the European Commission against Google for their anti-competitive ad tech practices. So at the time, the European Commission, and please, Alex, correct me if I'm wrong, was already considering looking into Google. And what we really wanted is making sure that we bring to your attention the challenge that Google's anti-competitive practices are creating for publisher. We wanted to expose it so that it can be addressed and remedied. In particular, and Ariel mentioned it, we wanted to bring forward the issue about Google's vertically integrated control over this massive market, which tends to be hidden in the background and not always very, very visible. But we wanted to also bring over this entrenched dominant, the distortion of competition, which all of this brought together really exerted a stranglehold, and I'm using past, I should use present, exerts a stranglehold over press publisher all across Europe, other market participants as well, but I'm here on behalf of publishers. So what we wanted is to, through that complaints, through that process, to seek the restoration of fair competition and rebalance in the digital advertising market, in order for publishers to be able to compete and to be able to monetize content, their content on fair terms. Because I think considering the size of the market, and considering the size of the company we're talking about, both on the buy and sell side, and thank you, Ariel, again, for explaining the entire structure, it is very important to understand how much publishers had become over time dependent on a company like Google, different tool that they use for the placement of advertising, where depending on which country we are in Europe, between 50% to 100% of the revenues of a publisher be triggered through display advertising. So I think it's absolutely essential to understand how impacted those companies have been while trying to pursue the mission of providing news and plurality of media in European society. So quickly, since its acquisition of DoubleClick in 2008. What we've seen as publisher with regard to Google, and Ariel again explained it very well, is really the consequences of foreclosure and of competition in the ad tech environment through that end-to-end control of the buy and the sell side on the entire value chain. I'm not going to go back to it. Adding to the control over both the buy and the sell side, Google was adding its own inventory to the mix, which really led to massive conflict of interest. And what we've seen is that as a company over time, what publishers have seen is that Google, in the face of those conflict of interest, has really, really taken advantage in order to prioritize its own interests at the expense of its very consumer. It had managed to position itself so that they could benefit their own interests at the expense of the company paying it, and at the expense of the companies, in that case, publishers who were dependent of that system in order to fill in their inventory. So in terms of harm, what we've seen is that we've experienced super competitive fees, we've experienced depressed revenues, but also, and I think it's very important to say, lower quality of service and a depreciation also in innovation, in the ability that a competitive environment in the ad tech ecosystem would create innovation and develop different tools and enable different ideas on how you place an ad, how you monetize content to actually thrive on the market. And that was completely cut from the market, and that really led to depressed publisher revenues and a very difficult situation for them to try to look for alternative solution elsewhere. And one way that made this very, very apparent, and Ariel mentioned it, is that at some point in time, an alternative technology, header bidding, was developed, and publisher really tried to use this way to have alternative bids, or to collect the bids from different auction. And what they saw for a very short period of time is that when a publisher was using header bidding, they were able to generate up to 80% higher revenues on average for their inventories than if they went through adtech. And that is in addition to the super competitive fees that we were mentioning of 20%, and the impact on revenues altogether when you're going through adtech. So cumulatively, it's a massive financial impact on publishers, with also a strong increase of competition with Google's own inventory that tends to be favored. What we've also seen, and I've mentioned the issue in terms of innovation, is that once Google had been able to put publisher in a very dependent position, we've had very little ability to create control over how we wanted the auction to be run, how we wanted the inventories to be filled. We've seen the issue of the first look, the last look that was mentioned. There was also the issue, for instance, at some point of the first price auction, which Google removed, where Google removed the ability for publishers to set buyer-specific floor pricing. And all of the different little steps that we've seen across the year was to really favor the Google adtech, so the ad exchange, and its own ad buying tool. And overall, it has penalized publishers that have not granted adtech preferential access to the inventory. So all of the different little steps, what it did is that incrementally it really pushed publishers into making their entire inventory available through the Google tools, but also at the same time making it highly dependent from that alternative, because the moment you want to go into an alternative, and mind you, the market offers less and less alternatives, you would actually not be able to monetize properly your inventory. So basically, in the past 15 years, the situation became intolerable for publishers. It has led to the point where the companies together decided that they cannot let the situation go on and something needs to be done. And that's why EPC, the European Publishers Council, decided to file that complaint with the European Commission. Now, this is not a complaint that was sent completely in a vacuum. It's important to also remember that back in 2021, we already had a decision from the French Competition Authority, which was following a complaint from a few publishers, specifically in France, some of them being EPC members, that led in June 2021 to the definition to that decision from the Competition Authority. Almost same case. The complaint was about Google using DFP, so double-click for publishers, their publisher site tool, and AdX, their ad exchange, together at the detriment of publishers. And the Competition Authority actually found Google guilty and fined the company 220 million euros, and also included some remedies at part. But to these days, they have not been effective to address the situation. So from a publisher's point of view, within EPC, pursuing legal action at European level was not an easy decision. Also because of the stronghold that a company like Google holds over publishers and over the capacity to generate revenues, to monetize their consent. And that's why we decided EPC was the right vehicle for it. And through the past 4 years, I hope we've been supportive whenever called upon to the work of the European Commission, providing information, but also letting you run your investigation and run the proper process. But if we have had the opportunity to provide input, I think we were more than happy to do that. I do want to mention one more thing is that we have in parallel, and when I say we, not EPC, but quite a number of EPC members, we have in parallel to the work that you're doing towards restoring competition, in February 2024, over 30 European media organizations, some of them EPC members, some of them not, have actually initiated legal action against Google to seek damages. And we're talking damages to the round of 2.1 billion. And this is a case that has been filed in the Court of Amsterdam in the Netherlands. And what we've seen also, especially also in the US, if I'm not wrong, and Ariel, correct me if I am, but also in Europe, we've seen some more cases following up in terms of seeking damages following to this abuse of dominance by Google. So we're very pleased with the ruling that took place in the US. We're very pleased with the decision that the Commission announced last fall. I'm not going to go into details because I know you're going to do it, but I think that now that we have those rulings, now that we have those decisions, we are in a situation where there's a strategic opportunities to rectify the problem that's been identified, the problem that's been investigated, and to restore competition in Europe, in my case, but also in the US, in European adtech, to the benefit of European press publisher, but also down the chain to European audience, to European readers, and to the rest of the advertising industry.
Thank you so much, Matilda. Really fascinating to hear your perspective on this. Alex, in September, the European Commission has published a nearly 400-page decision. Nearly or more than 400 pages, around 400 pages decision. Could you try to highlight some of the findings, some of the main findings, and the key similarities and maybe differences with the US case? Yeah.
Yep. Thanks, Lex and Mathilde. So first, to answer the most important question, the full decision is well over 500 pages. What we published in I think January was what we call a provisional non-confidential version with quite a very large number of redactions. So there are essentially after we adopt the decision, the company gets to make confidentiality claims. And in order to avoid sort of months of negotiation on those claims, we decided to publish a version that essentially treats all those claims as if they're valid, essentially. So you see there's a lot of the figures and the table, and the tables are missing. The juicy quotes and the internal documents are missing. We do plan to publish a sort of more fulsome version of the decision. But I'm afraid that's not going to be in the coming weeks or maybe even months. We'll have to see. So I'm going to try to go through a few slides quickly because a lot of the material has been covered by Ariel and/or Mathilde. And I will try not to repeat and also to leave room for discussion. So what am I supposed to press here to actually? There we go. Great. So I'm going to try to spend as little time as possible on this slide because it repeats a little bit the slide that Ariel showed with the structure from the DOJ document. And so, but here we see, I'm going to talk about it a little bit because it does help set up the description of the findings in the decision. So you've got here a simplified sketch of the adtech stack showing the respective Google tools at each level. So on the side of the publishers, which is the sell side, you've got the publisher ad server DFP, again, which is the tool that sells the publisher's ad inventory. That's why it's called the sell side. That tool manages the publisher's ad inventory and decides which bid essentially wins each ad impression on the publisher's inventory. Then you've got in the middle, but still considered generally part of the sell side, you've got the ad exchange, sometimes called the SSP layer. There are some subtleties and differences, but essentially these are the middle layer of the stack. And that's where demand and supply meet. So that's where that tool is meant to match supply and demand. And that tool there for Google is called AdX. And that's bundled with DFP under the name of Google Ad Manager, but they still largely perform separate functions. Then on the buy side, there are two tools. One is Google Ads, and the other one is Display and Video 360 or DV360. And those are the tools that on which advertisers upload their ad campaigns and which respond to bids from bid requests from the sell side. They send bids up to the ad exchange where then the auctions are held that decide which bids win the impression. So the key finding that we made in the September 5th decision is that Google is dominant on both of those ends of the stack, with DFP on the sell side and with the two buy side tools together, the two ad buying tools together on the demand side, the buy side. And that from both of those dominant positions, Google engaged in favoring or treating AdX more favorably than those tools were treating rival ad exchanges. And that's at the latest from 2014 onwards. I'm going to now move to the next slide. Yeah, thanks. So here again, the key findings are that Google has held dominant positions since at least 2014 in two broad product markets. One is the market for publisher ad servers for online display advertising. This is what we called them, the commission called them. You can certainly use different wording. And the other is the market for programmatic ad buying tools for the open web. And that Google has abused those two dominant positions to treat its own ad exchange, AdX, more favorably than it treated rivals. Those were two broad conducts, two broad infringements that we called the buy-side conduct and the sell-side conduct. Each of those also comprised several practices, which it would take at least an entire panel to describe in detail, I think. But Mathilde and Ariel have each mentioned at least a couple of them. One is last look. That's one of the more notorious ones, one of the more best-known ones, where essentially AdX was given the chance to bid for impressions, knowing what the amount of the highest bid was from header bidding submissions before it would bid. On the buy-side conduct, there were three practices. I think the simplest one to explain is simply that Google Ads, which is the single largest source of demand on display advertising, for a period of time, bid on no other exchange than AdX, then bid on other exchanges, but for a very, very small percentage of demand, and then in a final period, bid on a larger slice of demand, but essentially with weaker bids. And this is described in the decision. So if you're interested, you can follow up on these kind of wonky details. So those were two separate infringements, which we also called we used the concept of a single and continuous infringement, because we found that they each had the objective of protecting and strengthening AdX's position on the exchange market, which allowed it to maintain higher fees, and also, broadly speaking, strengthen Google's entire position all over the stack and made it sort of more difficult to disintermediate and to dislodge it at every level. As we often do in antitrust cases, the commission imposed a fine of just under 3 billion euros. That is not the highest fine, but it's up there in terms of the history of antitrust fines in Europe. It's relatively, I'm not going to get into the calculation. I think this is not a conference for competition lawyers. But basically, there's a methodology that's published. It's based on the value of sales of the product or services affected by the infringement times the duration, with certain other factors taken into account to either decrease or increase it. And the last finding, which leads me to the last slide on remedies, which is very important, is that when we took a step back and looked at the conduct, what we found, what we sort of diagnosed at the case team level, and this was translated into the decision, of course, is that Google's positions on the adtech stack, its dominance on both ends, right, and its ability to favor addex from both ends, actually gave rise to what we called structural conflicts of interest that enabled and incentivized the abuses. And these are visible. I mean, in the decision, you can sort of follow the chronology of some of the practices and see how one evolved into the other, how in terms of weighing the incentives between its customers and its own interests, Google tended to privilege the interests of addex. And so then I think we can move to the next slide. And here's something we don't often do, is that we haven't, so the adoption of the September decision is not the end of the investigation. We're continuing the investigation in respect of remedies because the commission, the decision ordered Google to propose measures to stop the infringement. This has basically two prongs. The first prong is that Google was ordered to discontinue those practices which were ongoing, the sort of normal cease and desist order in every antitrust decision. And then because of these conflicts of interest, the commission ordered Google to propose measures to effectively bring the infringement to an end by removing those structural conflicts of interest. Now, antitrust remedies in Europe broadly fall into two categories. They can be either behavioral, which are changes to the conduct or to the behavior of the undertaking which is found to have infringed the rules, or they can be structural, which can include but doesn't have to include requiring the divestiture of parts of businesses or of divisions or of subsidiaries. Behavioral remedies are far more common, but the Commission does have the power under the legislation to order structural remedies where these are appropriate. They have to be necessary, they have to be proportionate to the infringement, but the main principle of remedies is that they have to be effective. So where those are the only effective remedies, the Commission can order them. Now, Google has submitted a plan, as it was ordered to do, to comply with the decision. This was in November. The plan itself is not public, but Google has disclosed that it has not proposed a divestiture or a structural change to the business in order to comply. They have published a brief description of the measures, which you can find online. There's a blog post with a PDF link where there is a description. These are largely behavioral measures. We are analyzing this plan, still analyzing, to assess whether it complies with the decision, with the order of the decision. In order to do that, we've sent detailed questionnaires to many third parties, including the EPC, many individual publishers, also adtech rivals of Google, advertisers and agencies, basically every major player on the adtech ecosystem. And we're reviewing those inputs, those replies, as well as looking at other sources. This includes, of course, the record of the DOJ trial, the internal documents we've had on our file that we use in the investigation. We're looking at all these different things. And we have informed Google that we may still impose a specific remedy on them by another decision. Before this can be done, of course, we will respect Google's right to be heard. Google, not surprisingly, has appealed the September decision. Google will also have the right to appeal any remedies decision, and will have the right, in fact, to comment on any proposal before anything is adopted. And that's an important piece of the puzzle. So we're still some time away from a final resolution. And I think that concludes my slides.
Yeah, thank you very much, Alex. Tassos, so Mozilla is not of course, directly involved in this particular case, but you're also a very important stakeholder in a general debate. Could you maybe tell us how do you see the challenges in terms of like in both jurisdictions? Like what do these jurisdictions face, and what is the way forward?
Okay, so big question. Thank you, Lex. So yeah, Mozilla is, as you said, rightly so, not the direct participant in this case, but we've been obviously like for more than 25 years advocating for open and fair competitive markets and digital markets. And of course, privacy as well is top of mind. Like we do run and build a browser, which is quite central in our online experiences. So we do understand how many of those issues that exist in the advertising space have been developed over the years. I won't obviously go into the details because I think these have been covered quite extensively. But what I like to say here is that this is not, or at least the way we see it, this is not just a case about certain commercial practices and the competitive practices of one actor that goes beyond that. And it's mainly around how the advertising and the adtech market is structured as a whole. So it's for many years, this market has turned to be very opaque. It has been quite anti-competitive. It has been vertically integrated. And to that extent, we see it's explained by one actor being dominating the different layers of the stack, right? Like so, I think like both graphs that we've seen clearly explain that. That puts, of course, competitors in a disadvantageous position, but at the same time, every other player who is active in the space, they have to either follow the incentives of the business incentives of certain actor, and they have to abide by the technical infrastructure measures that they have, they're putting in place. Now, this kind of context, in my view, makes the remedies quite challenging. Deciding and finding the right type of remedy is quite challenging. You can take, like for example, like behavioral remedies, and while might not satisfy many actors because of the years of abuse that has been happening in that space, there is another challenge as well that comes with it, is that they require constant monitoring, right? And then it's a matter of resources and imbalance for those that they actually have like to monitor this type of remedies, and those that they actually, of course, are in the side of supposedly delivering on those remedies. We've seen that in other situations as well, that it's easy to comply on paper, or at least like show that compliance is according to the behavioral remedy set, but then the outcome or the value, the outcome of those remedies is not delivered. So there is one challenge there. The challenge with structural remedies, which of course can satisfy certain stakeholders, is how you design them, right? Like so, just putting structural remedies on the table and that's it. It will not be enough. I think they have to be definitely very effective. And the design part is very important. It's definitely concerning if we're in a situation where we are swapping one monopoly with another, right? Like, so for example, moving assets around, and then today is Google, tomorrow it's someone else, but then there's still like dominance in the market, right? Like, and then nothing really changes. So the goal here should definitely be creating the conditions to set to open up the market and also make it more contestable. In that case, of course, we can discuss like what a better version will look like in the future. What do we go from here, like for the advertising space? But I think we need to also take into consideration that this is a good opportunity to move away from a market that is highly concentrated, but also invasive for users. And there is a lot of incentives that are along the lines of trying to collect as many data as possible. Like there is a lot of incentives trying like to track as many users as possible, because that's where the value lies. Maybe it's a new good moment like for a bit of a paradigm shift in the advertising space. There is a lot of activity happening in different sides of the Atlantic. So I think the moment is ripe for that type of change. So happy to elaborate on that as well. Yeah.
Thank you very much, Tassos. I'll return back to Ariel. So Ariel, you did speak to us. You listed some of the remedies that are on the table in the US, but maybe you can tell us a bit more about, where do things stand right now? So what is your personal opinion, like, what the outcome will be in the US? And yeah, because you watched the whole thing play out, so it would be really interesting to hear that. And who do you think will benefit out of that outcome?
Yeah, sure. So I'll preface by saying that the remedies phase is certainly more challenging to predict. There are just a lot of moving pieces. So I feel that the DOJ did a fantastic job in demonstrating why divestiture is critical to mitigate conflicts of interest and the abuse of Google's vertical integration. The DOJ did a great job illustrating why, unless Google's incentive and ability both change, we will inevitably end up in the same position through different conducts. They had a visual that they showed referencing like a prior court precedent, showing all of the different roads to monopoly that Google could embark upon using various different conducts that DOJ could come up with now, right? But the reality is, as DOJ underscored, Google has essentially an innumerable amount of conducts, and it's impossible to foresee what exactly they might do in order to end up back at the same place. And I do think that was very effective, particularly that chart I remember resonating, in my opinion, with the judge. But Google fought back hard against divestiture. Similar to liabilities phase, though, Google called not one witness that hasn't been paid by Google. So even the small business publisher that Google called has a lucrative content licensing deal with Google, which came out during the testimony, during cross-examination. So Google's also faced with the fact that they had their evidence destruction looming over the trial throughout. And so between that and the many contradictions found in the documents that Google didn't purge or keep out of the record, the court's absolutely going to be skeptical when weighing their employee testimony. So for example, the court got really tired. During remedies, Google had done its own internal analysis evaluating the feasibility of divestiture, right? And they fought really, really hard to keep that out of the record. They were successful mostly, except there were little snippets of documents that made it in. And what Google said was that there's a difference between what they evaluated, which they called a technical divestiture, and a business divestiture. And at one point, the judge said something to the effect of, when a company makes a decision to sell, inherently there's an assumption that it's technically possible. So if you evaluated divestiture, then inevitably, like, you considered whether it's actually possible, right? So I think Google's strategy, again, was to distract and confuse, and they blended what I call their weaponized complexity approach with more fear-mongering around privacy, security, quality, advertiser return on investment. But just as the court found during liabilities that those quality and safety arguments were pretextual, I would hope for a similar outcome here. I do think, though, that some of that complexity, that weaponization of complexity, was more successful this time. So namely, Google basically tried to create a picture where its products are so helplessly intertwined and inextricably interwoven with its own infrastructure. And I think that argument didn't do very much during liabilities, but I do think that it created some confusion and uncertainty with the court this time around. And I do think, this is challenging for the court. It's basically one engineer and, employees of Google against other experts. And it's difficult to cut through the noise on really technical questions. But even here, DOJ successfully drew on Google's internal feasibility analysis to debunk a lot of this. And by the end, the judge was pretty clear, in my opinion, on what was hyperbolic of the technical experts. So on the merits, I would say divestiture is still on the table. I know that there's a lot of speculation that it's not going to happen. I'm more optimistic than that. I do think that the judge is more nervous about the ad server structural remedies. I understand why the DOJ proposed a phased divestiture, like that whole, we're going to open source the auction logic first, and then if that doesn't work, we're going to have Google sell it. I understand the logic, but that's really what created an opening for Google to create so much confusion around what's possible and not possible. It was simply like less clean. And so I do think that the court will worry that if this doesn't work out well, it could hurt publishers. Whereas if during liabilities, the judge said something to the effect of, well, what if we just blow up adx? And like there are plenty other ad exchanges in the market, it'll be fine, right? So I think that she's definitely a lot more cautious with the ad server piece than with the ad exchange. It's also very clear that the judge is concerned with both the timelines or the timeliness of remedies implementation, because publishers are still suffering as we speak, and also about the decision holding up on appeal. So I'd say, somewhat paradoxically, I would say divestiture of adx is maybe 75% likely, and the DFP structural proposal is I'm kind of 50-50 on. But that's, again, on the merits. And I say on the merits because the current political volatility is a bigger question mark, right? We expected a decision earlier this year, as early as January. And there's some speculation of whether settlement talks have been happening behind the scenes, though I personally don't think that would impact the court's timing. But Judge Brinkema herself suggested that this type of case would be best resolved through settlement. I just don't know how likely that is, given how much private litigation Google's facing right now. I think that they're going to feel that their back's up against the wall and that they have no choice but to appeal. So, to be clear, I think Google's sell-side divestiture is an absolutely critical and necessary first step for fixing the digital advertising market for publishers, advertisers, and all of us. Failure to curb Google's abuse now is only going to further bolster its dominance headed into this next AI-driven chapter of the internet. And, one of the most infuriating arguments Google made during Remedy's trial was that they pointed to publishers declining traffic as a result of AI and zero-click search as the reason that publishers are struggling today, to kind of take the pressure off. Like, it wasn't our ad tech abuses, it's AI search. And I'm like, you have AI over, what are you talking about? You've caused both problems, right? And I said at the time that for Google to point to the harms to publishers resulting from AI overviews to diminish the importance of resolving its harms to publishers related to ad tech is as absurd as it is arrogant. So to that exact point, weak remedies in this case would embolden Google and its broader big tech cohort. It would legitimize and even incentivize similar conflicted, vertically integrated models. And we see that metastasizing throughout the advertising industry. We see holding companies, agencies that traditionally served advertisers now sitting both on the sell side, owning an ad exchange, as well as on the buy side and operating data brokerage as well, right? So the stakes of this are very high. The scariest part to me is that I think that weak remedies here would seriously call into question whether antitrust frameworks are equipped to curb big tech's abuses now or in the future. And that's a scary thought. Although I will acknowledge that irrespective of the remedy here, all of that private litigation that's happening is allowing publishers a chance to have things made right. Right. And so it's not all for nothing if the remedies are weaker than I'd like, but it is a bit scary for the future of antitrust. Divestiture, on the other hand, would be a win for everyone. Publishers would get real choice in their tools, in their business for the first time in over a decade. Advertisers would get charged a fair share in a market where their money is competed for honestly. Market norms have a chance at evolving. Today, basically, Google is the de facto norm setter on like data collection, on vetting the inventory they monetize, on just about everything, right? So imagine a world where ad tech companies would compete on quality, on transparency, and a girl can dream, but potentially even on privacy, instead of doing whatever it takes to stay alive in Google's shadow. Journalism gets a fighting chance at the revenue that it was always owed. And ultimately, the world gets a precedent that big tech actually can be dismantled for its harms and abuses and not just scolded.
Thank you so much, Ariel. Matilde, what is your position about the remedies? But not only just the remedies on adtech, but generally other competition issues, broader competition issues in the market.
Right. I absolutely agree with Ariel. I think the remedy phase is the most important. I mean, we've had the first step, it looks like a big win, but actually this is the part that we need to get right if we actually want to have changes brought to it. And I will just add a little disclaimer that in the US, the trial took place last October, if I remember correctly. In Europe, this is still, as Alexander's mentioned, this is still an ongoing. So here we are, here's where we are. Overall, what do we want as publisher, as EPC? What we want is a healthy, competitive ad tech ecosystem which can benefit publisher as well as advertisers and ultimately our readers. We want obviously fairer pricing, but we also want transparency. We want to be able to choose our partners. We want innovation to be stimulated. We want market choices. So that's what we want. So how do we get there? I think it's the very important point. So in the US case, the DOJ has requested divestment of adx. I think there are a lot of open discussion to be had on, as you mentioned, whether it should be the entire GAM, the Google Ad Manager, or just adx, and what do we do with DFP? Another point that I would like to mention is that I think, and before I go on, I think it's interesting to also not always oppose the two types of remedies, especially when, such as in the DOJ proposal, we have a timeline issue. There is a proposal to divest the ad exchange, and then there's behavioral remedies. And if the behavioral remedies fail, then you will have further divestment of the DFP, if I got the DOJ proposal right. But I think considering the timing on a lot of issues, it's important to sometimes look at both into combination and not just one or the other. So that said, when the European Commission issued its statement of objection, that was in June 2023, back then, Commissioner Vestager made clear, and I think it was a quote from her, a behavioral remedy is unlikely to be effective at stopping the anticompetitive practices. And that's an old quote, but that's a quote we very much like. So against this background, structural remedies, divestment of Google, has to be part of the conversation, and that's something where, from an EPC point of view, very much want to be part of the conversation, but all options are on the table. We have to consider all the different approach, but whatever comes out of the remedy discussion must do what I said, restoring competition, address effectively the structural conflict of interest that we've exposed, and identify and address, the concern and foreclose them. So, you've mentioned Google sent you a compliance plan back in November, and you've consulted a number of organizations, number of stakeholders. We were consulted, so we had the opportunity to provide feedback on the Google compliance plan. Overall, and without going into the details, disclaimer I mentioned, we have received the plan quite poorly. What we felt is that, and we told the Commission so, you're very well aware. First of all, we felt that the proposal from Google, which, as mentioned, did not include structural remedies, only focused on behavioral one. We felt that the proposal were extremely minimalistic, but also, and that's one of the issues, also were very vague and left a lot extensive discretion to Google on how they would be interpreted. For instance, there was a lot of the provision that included depending on the Google policies or subject to interpretation. So the compliance to those remedies would actually be left to Google on a sort of a self-policing kind of structure. Therefore, their effectiveness would be extremely difficult to monitor, especially when we look over time. Those are not remedies that have to be implemented on just one day. We want to see on the long term how the market is going to be impacted. So we have to take that long-term approach into consideration. And overall, what we felt was the remedies were very unlikely to effectively address the issue at stake. So what do we want? How do we want? And I think it's more important, without going into the technical details, how do we want the remedies to work? If we're talking about behavioral remedies, I've mentioned structural remedy there, but if the regulators were to take the route of the behavioral only remedies. What we want is those remedies to be extremely clear, so there is no room for interpretation at what conduct are we expecting from the company. There should be no opening of interpretation. Their enforcement must be monitored over time, and we need to take into consideration the asymmetry of power and the asymmetry of information that would exist between a company like Google and whatever monitoring body, whether it's the commission or else, would be responsible for it. We basically, I think the bottom line is we basically can't be asked, especially from a publisher's point of view, to simply trust Google is to do the right thing. We can't ask the company to, we can't be asked to trust that this company is going to do the right thing over time. So that's the first thing. The second thing is, I think that when we're having a discussion on behavioral remedy, we need to be forward-looking. Ariel mentioned PMAX and how Google has been progressively moving advertisers toward that type of advertising model. And I think it's very important to keep a broader perspective on how the ad tech ecosystem is functioning and how the technology is evolving from one tool to another. Because having a behavioral remedies on the ad exchange solely, for instance, or on a few limited aspects, may become completely useless if in 1 or 2 years' time, the entire ad traffic is going through another model, which is yet again controlled by Google. If it's in a black box, AI-powered, where we don't have any visibility in there, and it's just basically going back to point zero. So we're really arguing to try to get that broad vision about how is the advertising market working? And you mentioned something very interesting, Ariel, which is it is a highly technical environment. Anyone who hasn't spent extensive amount of time trying to understand how it works, it is very difficult to kind of see where are the knots, where are the funnels, where are the technical standards that are going to inflow money or advertising inventories one way or the other. So it requires a lot of experts to be able to look and to be able to anticipate what changes is going to work in one way. So we're not in an easy environment, but being forward-looking is an absolute essential. You've mentioned other cases. So EPC, we're definitely not Google's best friend. You've mentioned the issue around AI overview, I think a bit earlier in your intervention. Well, obviously, the integration of AI moment and AI overview in Google Search, which is the largest search engine in the world, is a massive issue for publishers, because it basically keeps users in the Google environment providing answers to their queries, so that to the point that they don't have to go on publisher's website. I will put on the side how is Google getting that information in the first place, because this is not a room full of competition lawyer, and I am also not doing with, copyright lawyers, and I'm also not a copyright person. But the EPC, we decided, because of the urgency of the situation and because of the fast pace that this new environment, that turning a normal search engine into an AI-powered answer engine has such an impact on publisher, we decided to fill yet a second complaint to the European Commission antitrust against Google on AI overview and AI mode, to yet again put light on that particular practices and the impact that it has on publisher by systematically substituting the publisher's original journalistic content to their own answer and keeping individual in their own environment, which directly impacts advertising revenues. It displays traffic and audiences and a lot of other aspects. There are information on our website if you want, but it's the entire environment that is problematic. So we have that second complaint in a very rapid environment. I can only hope, and I know you're very, very busy, that the Commission is going. I know the Commission is looking at it already, but we can only hope the pace is going to go faster. But overall, yes, we need your help.
Alex, would you like to comment maybe a bit about the broader competition landscape and yeah?
There's certainly a lot to comment on there. I think in terms of the compliance plan, in terms of the responses from third parties, I think I'm definitely not in a position to comment without risking crossing the line. I would certainly first take a step back. I would mention that in fact this complaint on AI overviews was received after we actually opened formal proceedings. So it did not provoke the investigation, which is also the case for adtech, by the way. But I think that shows that this is the kind of thing that the relevant services in the Commission, at least in DG Comp, are entirely aware that this is important to publishers. It's important to the media ecosystem. It's important to a lot of players. Indeed, it implicates copyright issues, many issues beyond competition law, and there's a certain amount of, one needs to sort of balance all these things, but we are alive to the issue, and we're definitely treating it with high priority. I think both Ariel and Mathilde have mentioned remedies kind of like specifically in respect of this case. I would just say that generally speaking, I think that this case, the adtech case, is a good example of how the approach of competition authorities to remedies, and I think that I definitely think that this is the case for DG Comp. I think it's probably also the case for other authorities around the world, is changing. I think that there may have been a perception in recent years that basically what happens is that authorities will maybe adopt a decision and fine, and then move on to the next case, right? What DG Comp did in the last couple of years was that it actually had a contractor perform a study, a sort of ex post review of antitrust remedies, where I think that the report was published with a number of recommendations. One of them maybe was to sort of bifurcate the infringement phase with the remedies phase, which we were already doing, in fact, in this case, but that has become a thing that maybe we'll do more often, especially in the more complex cases. I don't know. And I think that the fine here, I mentioned the fine earlier when I was speaking. It's just under 3 billion euros. That's a big number, but it's less than 1% of Google's turnover, right? So I think that in the last few years, as authorities have been kind of coming to grips with the various competition issues that are raised by these giant platforms, one of the issues has been, are the fines deterrent? And of course, the fines are to punish past conduct. Remedies are something else. Remedies are to sort of fix the problem on the market in the future. But I think that part of realizing the importance of remedies is also realizing that the fines, while important, and there is also, of course, the private damages actions. I mean, there's the damages actions in the US. There are also damages actions in Europe, which are growing since there's been the ECN directive. The damages directive, rather. Those are all important things, but remedies are also really, really important. And so entirely agree that we have to get them right. That means that maybe, we might consider structural remedies or extremely, extremely sort of complex and strong behavioral remedies in situations where maybe we wouldn't have several years ago.
Just to come back to one point you said, which I think is very important, are the fine deterrent? And I think it's very, very important to ask ourselves in the field of competition, especially in the field of big tech, because more and more the impression that we have is that basically the fine is just the cost of operating a business. And considering the size of those massive company, it's a budget. It's one line on a massive budget. It's less than 1% of the Google revenue. So when companies are looking at fine as this is just the cost for me to run my business, then we do indeed, as you mentioned, have to rethink how much of a deterrent it is. And that does put a lot more emphasis on the work that you are doing and the work that the DOJ is doing with regard to the remedies, because ultimately they are the area where changes can come from.
So I'll go to Tassos now. To Tassos, you actually mentioned that this is a very online advertising being the business model on the internet. This is very important to structurally and looking in the future. You see these cases affecting it in a major way. Are we seeing a new era in online advertising, or is it just business as usual? What do you think?
Yeah. So I think Ariel mentioned it already, and then I tried to mention it as well, and Mathilde is very aware of that, given working in the publisher space. Advertising is the way we fund the web, right? The open web. And that should remain the case. The question is, of course, like how do we do advertising, right? Like, so that's very important thing to have in mind. Therefore, here we're not talking about doing away entirely like with this type of financial model, because then we are going to end up in a very closed web. Like we're going to end up in trying to fund content online in ways that probably most users wouldn't want to and wouldn't be able also like to sustain and bear, right? One quick point on the fines, because I think it's a very important one, and we should definitely like have and keep having this this discussion. I fully agree that there seem to be like one budget line, right? Like in they're probably like a fraction of what these companies are making. However, I'm optimistic, like Ariel is, that we're probably we're in a different space than how we were like years ago. And first thing that comes in mind, of course, we have a lot of fines coming out of the European Commission for many right reasons. But for example, we also have on the table another tool, which is a Digital Markets Act, that is something that we didn't have many years ago, right? Like, so there is definitely an improvement in the space. We're thinking ex post, we're thinking ex ante, right? Like, so we are obviously having we're moving forward. I think also like structural remedies, for example, is something that maybe was more of a taboo like in the past, but now like we're actually putting it on the table for right reasons. So definitely an improvement there as well. Now, looking forward and maybe also like a bit beyond this specific case, probably there is, I'm going to use a very kind of classic term these days, we're at an inflection point. The reason why I say that, like we have two roads to take, right? Like one would be staying a bit on the business as usual side of things, making like some tweaks here and there, and then maybe not being as bold and effective in terms of like how we can reform the advertising market. That will probably not bring the change that many of us want to see in order of opening up and creating these fair and contestable markets that we talked about before. So I think the other path that we should be looking into is what type of tools we have in the arsenal in order to be able to create these open, fair, and contestable markets, advertising or otherwise. That would be a lot of focus, of course, on effective enforcement of existing rules, ex post, ex ante, would be on adopting effective remedies that I know that Alex and the Commission is, of course, looking into it. There is the growing pressure that we mentioned before also in the other side of the Atlantic. Advertisers and publishers are rightly so putting all the evidence on the table on why they are suffering, and also users are actually bringing a lot of those points forward, right? Like users, if we do like a bit of a quick poll, of course, like no one wants to be tracked, like they're concerned about the privacy online. So we should always like keep in mind that this market that is vertically integrated and locked up, and it's a closed ecosystem, it doesn't mean that we should not try to open it up because they are privacy or other similar concerns. Ariel made a very, very good point before of weaponizing privacy and security. This is a classic argument and a classic tactic or technique by bigger players or big tech players, right? Like, of course, it's interesting like to put this type of false dichotomy to people, and then you're concerned, like if I open up the market, I might have less privacy or security, or I want to have privacy and security and I don't care what the rest of the ecosystem will do, right? So we should move away from that. The two can go hand in hand. I think there is a lot of good examples to take from the Digital Markets Act. There is also a lot of tools that we have in our arsenal, which is focusing a lot on adopting open standards, right? Like we can focus a lot on adopting interoperability mandates. There is a lot of good elements that we can adopt in our thinking on how we can reform the advertising market. And I would even go as far as saying that maybe at some point we need to put back on the table, if it were ever on the table, a dedicated legislation on adtech, on advertising tech, right? Like, so just in order to, of course, we need to start by the transparency and the auditability aspect of it. We need to first of all understand how the system works. I think Ariel might know a bit. I definitely don't know. And then maybe Matil has a good experience like with publishers or Alex, but it's something that is a very big black box for many of us, right? Like, so we need to first, of course, understand how that market works, and then make sure we're making the right interventions, not for the sake of making them, but it's definitely something that we should consider. I don't think in this mandate, but maybe in the next mandate in Brussels, something that we can have in mind.
Thanks, Tassos. I loved it. I was like, here. I didn't know he was gonna say that, but I like adtech regulation. We unfortunately we passed the time. I want, because we have 2 minutes officially left, but like maybe we can extend a bit. Let's hear like 2 questions, 1 or 2 questions if there is in the audience. Otherwise, I'll come back to you, Matilda. So questions, please. If there is any, if I don't see a hand, I'm going back to Matilda with Matilda. It is your time to comment.
I think it's very interesting what you're saying, but definitely one point you've mentioned, which I find really interesting, is the DMA. The DMA definitely shows that we're not where we were 10 years ago. There is this idea that we need to anticipate a little bit more. We need to be more vigilant with regard to companies that are already in a gatekeeping position and how they can actually instrumentalize. So we've learned a lot, and the DMA is a proof for that. I mean, obviously, the proof is in the pudding. It's about enforcement. It's about reactivity to everything. It's about making sure that we react whenever there is a new investigation, whenever there is a notification, and basically, the rules are there. They might not be perfect. We might have to revisit that in the future, but we have already a good framework to start tackling some of the issues which before used to be tackled in the field of competition only after. Or much later after. And for instance, one of the cases, and we're back on Google, is the self-preferencing case in the search environment. That's already a case under the DMA that we're looking into. So yes, there are some tools, and there are a higher level of awareness that is there, so we can try to push things in changing.
All right, thank you very much for all the panelists. Thank you, Ariel, for joining online, and please join me to thank the panelists.